Well, welcome to the I Got Fired podcast for people who've been fired or afraid that they might be. And I'm thrilled today to be joined by Kristen Farr, an attorney in our office who's going to talk to us about filing unemployment insurance for unemployment insurance coverage in the state of Maryland during this COVID-19 crisis. So welcome, Kristen.
Good afternoon. Great to be here.
Okay, you want to tell us a little bit about yourself?
I've been practicing employment law for over 10 years now. I've had a lot of experience with unemployment claims and going through the appeals process and getting people benefits for those applications.
Okay, great. Well, we will go ahead and get started. Well, obviously the landscape for unemployment insurance has changed nationwide. But let's start in Maryland. What's different about unemployment insurance now? What are people eligible for that they would not have been eligible for before?
So a new law was passed in Maryland last week, expanding the reasons that you can be eligible for unemployment. So if your employer is closed due to COVID-19, you can apply for benefits. If you yourself are quarantined due to COVID-19, you can be eligible for benefits with the expectation that you return after the quarantine is over. And then if you leave your employment due to exposure or the risk of exposure or infection of COVID-19 or to care for a family member who has COVID-19, you are also eligible for benefits. So that's the big change in Maryland.
Yeah, let me just interrupt real quick. So that's pretty substantial. And because it used to be that you got unemployment insurance essentially if you were fired or let go for whatever reason, and it was for some other reason other than misconduct. That was basically it, right? Like there were none of these other exceptions applied. We are getting a lot of questions, I know, at the firm about people who want to know what their rights are. Can they, if they're worried about returning to work. So it's good to know if there's a risk of exposure to COVID-19. So it's good to know that, if you lose your job for that reason, you can still get these unemployment benefits. But I'm sorry, go ahead, I interrupted.
Well, I was just going to talk about the federal expansion. Did you want to get into that now? Or,
Sure.
Okay. So the Maryland has opted into all three of the additional benefits that the federal Coronavirus Aid, Relief, and Economic Security Act provides. So you get $600 additional compensation, and that's effective March 29th of this year. You also get an additional 13 weeks of benefits, which includes the $600. And then for those employees that are independent contractors, are part of the gig economy, who are normally not eligible for benefits, they can be eligible in this situation if they are not working due to COVID-19.
Which is a big change, right? Because it used to be if you were an Uber driver or, if you were with a delivery service and you got fired, you could, because your employer was not paying for unemployment insurance on your behalf, you weren't eligible. So this is a big difference for people who are part of the gig economy, who are independent contractors, now can be eligible. Yeah,
big change. However, it's not set up yet for those people. If they do apply, they will be denied at this time. So just give it some time for the system to make those changes. You can go to the Maryland Unemployment Insurance website and enter in your email address for updates on that. They'll let you know when the system is updated to account for that. One nice thing about Maryland is, unlike many states, there's not a waiting period for eligibility. So you are eligible for benefits the week after you're terminated. So even if you can't apply immediately, you are still eligible going back to that time period.
Okay, great. So, and I should say, this is being posted, March 31st. So depending when you watch this, some of these issues may have been resolved, but that's good to know. Okay, so if somebody wants to apply, I'm going to pull up a website that you shared with me so folks can see it. So this is Maryland Department of Labor, Division of Unemployment Insurance. And we'll post this link for those who are listening to us on the podcast and the show notes. But you want to walk us through this? What's important? What do folks need to know?
Sure. So one thing that's a little different is due to the large number of claims, they're asking you to apply on a certain day based on your last name, so that the system is not overloaded. If your name starts with A through F, you file your claim on Monday. So again, due to the fact that there is no waiting period, even if you apply later in the week and you are awarded benefits, it will go back to the time that you were terminated. So there's no impact on the amount of benefits you have. So please do follow their list there so that there's not a system overload. And then there's a link there, net claims application. You can file online, or there are some numbers you can call in. There are certain types of claims that cannot be processed online generally. So those are the numbers down there to call to file over online.
What kind of claims can you not file online?
Yeah, so if you if you earned wages in a state other than Maryland in the last 18 months, you worked for the federal government in the last 18 months, you worked for more than 3 employers in the last 18 months, or you filed for unemployment insurance in another state in the last 18 months, you are not eligible to file online.
Okay. All right. And so then you would just, you file a paper copy, or?
You can call the claim center there and file. You can call that number or your local office if those are still open.
Okay, so just important to remember. So you see this hyperlink here, net claims application. That's where you would go to file. Okay, good to know. All right, so I know things are a lot different now. I don't know how much employers will be. Let me back up and ask you, do you have a sense of once you apply, when you start getting your check?
So yeah, I'm not sure of that timeline. I mean, unfortunately, with the number of appeals or the number of claims being filed, it could be taking a little bit longer to get all of those processed. So yeah, I'm not sure what the timeline is there.
Yeah. Okay. So they could probably call the claim center and maybe have to wait a little while, but could probably get a sense of how long. I imagine they're trying to get checks to folks pretty quickly.
Yeah, they are.
Yeah. Let's see. So I know under normal circumstances, I don't know how much employers will be contesting unemployment insurance claims. I bet few during this time. But if that happens, what is the standard? How would an employee, somebody who's just been fired or filing for unemployment, and their employer says, they're not entitled to this? How does that work?
Yeah, so you can be denied benefits for misconduct, and there are 3 levels of misconduct in Maryland. Simple misconduct, which is generally just negligence, unintentional violation of the employer's rule. You can be denied benefits for 10 to 15 weeks after your last date of employment. So you can still get benefits, you would just have to wait that time period. For gross misconduct, you are not eligible for benefits at all until you are re-employed and have earned 20 times your weekly benefit amount. So gross misconduct is a deliberate or willful disregard of an employer's standards of behavior or repeated violations of the employer's rules. And then finally, there's aggravated misconduct, which the same limitation of gross misconduct. You are not eligible until you're reemployed and you have earned 20 times your weekly benefit amount. But an additional penalty is that the wages you earn from that employer are deleted from the calculation of your weekly benefit. And aggravated misconduct is malice, an intentional act, more so than just gross misconduct. But
if you punch your boss in the nose, that's,
yeah, exactly.
That's aggravated misconduct. You're probably going to get arrested as well. So, and I know that there is a procedure, and we don't have to go into all of it, but so in most states, the way it works is that, you apply for unemployment insurance, your employer is contacted and given the opportunity to contest it. If your employer contests it, right, it's not just automatic that you don't give it. I mean, they don't give it, like there's a hearing, right?
So there will be a local level determination based on the information you provide and the information provided from the employer. If that is not in your favor, you have 15 days to appeal. And that process, it's 15 days to appeal. Generally, that has to be mailed or faxed. They are making an exception now that you can email to ui.lowerappeals.labor@maryland.gov. So you can appeal via email. You just want to include your name, the last 4 digits of your social security number, the determination date, and a brief statement of why you disagree with the determination. And the hearing will be held after receiving that appeal.
And so the lower level determination is that, I mean, it's like a mini trial, right? I mean, it's like the employer, at least the way it works in Virginia, I mean, you can tell me this way it works in Maryland, like it's on the phone and there's a hearing officer on the phone, and they don't even necessarily have to be an attorney. They hear the employer side. They can take evidence in the sense that they can request documents and things like that. You get to present your side, and then the hearing officer makes a determination and issue in writing. So they have the hearing, then you get something in the mail that says, this is what the hearing officer has determined, and then you can appeal it. Is it the same kind of process in Maryland?
So that is the appeal. The local office they may interview you, you may provide information to them, but the appeal is to get that hearing at that stage.
Got it. So you do have at some point you have an opportunity to present your side. Which we've represented, as you know, in our firm, we've represented some folks in these hearings. You don't have to have a lawyer or be one to be in the hearing. Is that right?
Correct.
Yeah. Most of them are designed, it helps to have a lawyer, but most of them are designed not to have a lawyer. And often even your employer is not going to have another lawyer on the phone. Often it's somebody on HR. I mean, they might, but it's often somebody from HR. And the reason being is because, lawyers can be expensive and the dollar amounts at issue can be relatively low. And so often attorneys aren't involved. That said, you can have an attorney at the hearing if you'd like.
Yeah, there's also a few companies that offer these services to employers. So they aren't attorneys, but they are people that have specialized in unemployment claims and defending employers in these matters. So that's, if it's not the HR person handling it herself or himself, then it might be one of these outside organizations that are designed for this purpose.
Specialize in doing that. Yeah, that makes sense. And I would say, you know, and you, Kristen, you can certainly weigh in, but you know, if you're doing one of these on your own, you know, have your evidence. You know, for example, I remember we had a case years ago where the company was alleging that the woman had not called in, that she'd been fired for no-show, and the woman had her phone records, where she could demonstrate that in fact she had called in. And so she won you know, the company tried to deny to unemployment. And the reason companies do this is there is a slight tax distance. The companies, their taxes can be raised in certain circumstances. Their unemployment insurance tax, if they lose a certain number of these. So that is the reason that sometimes employers will contest them. But she won that. So, you know, if you have that evidence, again, you know, pull it together. You know, hearing officers, you know, they'll usually will accept those kinds of documents. And, you know, if you've got people that can issue statements, those sorts of things, all those can be helpful.
Yeah, or your witnesses, you can call witnesses as well, your coworkers, or, you know, somebody that could counter what the employer is saying is also beneficial.
Yeah. You know, and you can, like I said, you can have an attorney there. Sometimes it doesn't make sense economically to have one there, but even if you can't, you know, my recommendation would be, if you're trying to keep costs down, is to have a consultation with an attorney, you know, talk to them about, you know, what the allegations are, why the company's trying to deny insurance, and like help, you know, the attorney can give you some advice and help you think through how to present your best case possible.
Yeah.
All right. Anything else that I've left off? Or anything else you want to add to that?
No, I think that's it's generally it in a nutshell.
Yeah. There's one thing I do want to add. I do know that sometimes it is helpful if you have an ongoing case, I mean, like a discrimination case, let's say, because you can have them both, right? You can get fired for a discriminatory reason. You know, you apply for uninsurance benefits, your employer can test them. So you've got that going on, and you've also got a potential lawsuit for, let's say, discrimination. It can be helpful, you know, to have the unemployment insurance hearing, and they're often, like I said, they're often telephonic, sometimes, at least in Virginia. But nevertheless, whatever form it occurs, I don't know if this is true in Maryland. In Virginia, you can't use like with statements in these sorts of hearings in a court proceeding. However, you can learn what the other side is saying, right? Because it's often an overlap. Like whatever wrongdoing the company is alleging is also the wrongdoing that they will allege was the reason they fired you, not for a discriminatory reason. So sometimes that can be helpful too. And of course, if you've got an attorney that's representing you in the discrimination matter or the wrongful termination matter, you know, he or she can often help you with the unemployment piece too. And, you know, win or lose that case, you often get some good discovery. You find out what the other side is going to say.
Yeah, I mean, the employer will also most likely produce evidence to use at the hearing. So if they said that they are firing you for reason X and they presented documents for that, if you go forward with litigation and suddenly they're saying, oh, we fired you for reason Y,
Right.
you know, that can undermine what they, you know, that position, because if that's true, why was that not brought up at the time closer to the termination? So
Yep.
It can be beneficial for gaining information.
Yeah, absolutely. All right, very good. Well, before people jump off, I just want to show people our website, spigglelaw.com. If you have questions about this, or you think, because a lot of times there is an overlap, you're fired and you're able to apply for unemployment benefits, and it was for a reason for wrongful termination. This is our website here. You can go to our no-cost online review on the right-hand side, or you can call us, call the office and speak to a real person. We'll see if you can help you out. But I hope this helps folks file for unemployment insurance. I know it's a difficult time for people. And Kristen, thanks for joining today.
Sure. Talk to you later. Bye.